Video, we will explore how trusts play a crucial role in business succession planning. If you're looking to ensure the smooth transfer of your business to the next generation, stay tuned. Business succession planning is essential for the longevity and stability of a business. Trusts are a powerful tool in this process, helping manage and transfer business assets effectively. So, what exactly is a trust? A trust is a legal arrangement where one party, known as the trustee, holds and manages assets for the benefit of another party, the beneficiary. Trusts can provide several advantages in business succession, such as maintaining control over assets, offering tax efficiency, protecting against creditors, and ensuring continuity and stability. There are various types of trusts used in business succession planning. Let's briefly discuss some of the most common ones. Revocable trusts allow the business owner to retain control over the trust assets during their lifetime and make changes as needed. This type of trust can avoid probate, ensuring a smooth transition of assets to the beneficiaries upon the owner's death. Irrevocable trusts, on the other hand, cannot be modified or revoked once established. These trusts provide significant tax benefits by removing assets from the owner's taxable estate and offering protection against creditors and lawsuits. Testamentary trusts are created through a will and become effective upon the owner's death. They allow detailed instructions for asset management after death but require probate before becoming effective. Charitable trusts are designed to benefit a charitable organization while providing tax benefits to the business owner. These trusts can ensure that a portion of the business assets supports charitable causes. Using trusts in business succession planning offers several strategic benefits. Trusts can help avoid the lengthy and costly probate process, maintain confidentiality, ensure business continuity, provide flexibility in asset distribution, minimize family disputes, and protect beneficiaries. To implement a trust in your business succession plan, follow these steps. First, assess your business and personal goals. Determine your objectives for the succession plan and identify key individuals involved in your business. Next, consult with an experienced attorney to explore your options and create a tailored plan. Choosing the right type of trust is crucial, as it should align with your goals and provide the desired benefits. Draft the trust document, clearly outlining the terms and conditions, as well as the roles and responsibilities of the trustee and beneficiaries. Then, fund the trust by transferring ownership of the business assets into it. Communicate the plan to key stakeholders, including family members and business partners, to ensure a smooth transition. Regularly review and update the trust to reflect changes in business or personal circumstances. Consider the example of a family-owned manufacturing business. The owner, nearing retirement, established a revocable trust to transfer ownership to their children. The trust included specific instructions on management roles and profit distribution. By doing so, the owner ensured a clear management structure, tax efficiency, and continued business growth under the new management. In summary, incorporating trusts into your business succession plan can provide numerous benefits, including control, tax efficiency, and asset protection. To secure the future of your business, consult with a professional attorney and develop a well-structured trust plan today. Thank you for watching. If you found this video helpful, please like and subscribe for more content on business succession planning.
Join us as we take on the challenge of organizing the essential documents needed for a comprehensive estate plan and learn how to avoid costly mistakes along the way. Estate planning is often viewed as a complex and daunting task, but having a comprehensive plan in place can provide peace of mind and financial security for you and your loved ones. If you don't have a proper estate plan in place, your family may be left to deal with the fallout, which can lead to lengthy and costly probate battles, family disputes, and even financial devastation. Without a clear plan, your assets may not be distributed according to your wishes, and your loved ones may be left with a huge mess to sort out. In addition, if you become incapacitated, Your family may have to go to court to get a conservatorship, which can be a lengthy and expensive process. Furthermore, your medical wishes may not be respected, and your family may have to make difficult decisions on your behalf without knowing what you would have wanted. Moreover, without a comprehensive estate plan, your business and personal assets may not be protected, leaving them vulnerable to creditors, lawsuits, and other risks. In the worst-case scenario, not having a proper estate plan can lead to family feuds, lawsuits, and even financial ruin. It's a heavy burden to place on your loved ones, and it's one that can be easily avoided with a little planning and foresight. A comprehensive estate plan consists of several essential documents that work together to protect your assets and ensure your wishes are carried out. These documents include wills, trusts, powers of attorney, and healthcare directives. Each document plays a vital role in ensuring that your assets are distributed according to your wishes, your loved ones are protected, and your medical wishes are respected. A will is a legal document that outlines how you want your assets to be distributed after you pass away. It's a crucial document that ensures your wishes are carried out, and it can also appoint guardians for minor children. Trusts, on the other hand, are legal arrangements that allow you to transfer assets to beneficiaries while minimizing taxes and avoiding probate. Powers of attorney give someone the authority to make financial and medical decisions on your behalf if you become incapacitated. Healthcare directives, also known as living wills, outline your medical wishes if you're unable to communicate them yourself. Each of these documents is essential to a comprehensive estate plan, and they work together to provide a complete picture of your wishes and intentions. By having all of these documents in place, you can ensure that your loved ones are protected, your assets are distributed according to your wishes, and your medical wishes are respected. It's a vital step in planning for the future and avoiding costly mistakes. By having a comprehensive estate plan in place, you can rest easy knowing that your loved ones will be protected and your wishes will be carried out. If you don't already have a comprehensive estate plan in place, we encourage you to take the first step and schedule a consultation with an estate planning attorney today. It's a small step that can provide huge peace of mind and financial security for you and your loved ones. For less than the cost of 1 month in a nursing home, this strategy can protect your entire life savings. The cost of nursing home care can be overwhelming, often exceeding $9,000 per month. Medicaid rules require that your assets fall below a certain limit before you can qualify for free nursing home care. This asset limit is often shockingly low, $2,000 in many states. This means you'll have to deplete your entire life savings before you can receive assistance. However, there is a solution: an irrevocable trust. By creating an irrevocable trust and transferring your assets into that trust, you can set aside and protect assets and qualify for Medicaid. When you transfer your assets into an irrevocable trust, the assets are no longer considered yours. The trust owns the assets. This means if you transfer your assets into this trust and you fall within the Medicaid eligibility limits, you can qualify for Medicaid without spending down your life savings. By using this strategy, you can qualify for free nursing home care while your assets in the irrevocable trust are protected and set aside for your loved ones. However, it's important to note the 5-year look-back period. Medicaid reviews your financial transactions for the past 5 years, and any transfers made during this period could result in an ineligibility period. Assets transferred longer than 5 years ago do not affect your eligibility. If you expect to require nursing home care within 5 years, you can still benefit from this type of estate planning, but the results are much more limited than if you planned at least 5 years ahead. Therefore, planning ahead is crucial. Start planning today to protect your hard-earned assets.
What is a funeral trust fund? A funeral trust fund is a legal agreement that allows you to put aside funds for your funeral and burial expenses. This ensures your final wishes are respected and eases the financial burden on your loved ones. Why is a funeral trust fund necessary? A funeral trust fund is necessary as it offers peace of mind, knowing your loved ones won't have to bear the financial burden of funeral costs. In addition, it provides assurance that your funeral and burial will be conducted according to your preferences. How to set up a funeral trust fund? Setting up a funeral trust fund involves several steps. Determine the amount. Consider the type of funeral you want and the costs associated with it. Include all potential expenses such as the casket, burial plot, and services. Choose a trustee. This could be a family member, friend, or a financial institution. The trustee will be responsible for managing and disbursing the funds after your demise. Create the trust document. This should be done under the guidance of an experienced attorney to ensure the document is legally sound. Fund the trust. You can fund the trust with cash, bonds, life insurance policies, or other assets. It's essential to discuss the most suitable funding option with your attorney. Legal considerations for a funeral trust fund. Funeral trust funds are subject to certain laws and regulations. It's crucial to understand these laws to ensure the trust fund operates as intended. An experienced attorney can guide you through the process, ensuring all legal requirements are met. Advantages of a funeral trust fund. A funeral trust fund offers numerous benefits to the settlor and their loved ones. These include quick accessibility of funds. Unlike other estate assets, funds in a funeral trust are immediately available upon the settlor's death. This eliminates any delay associated with probate and ensures funeral expenses are promptly covered. Flexibility. Funeral trusts can be tailored to meet your specific needs and wishes. You have the freedom to dictate the type of funeral service you want and how the funds should be used. Financial security. A funeral trust fund can alleviate the financial stress on your loved ones after your demise. Knowing that funeral expenses are taken care of can offer them much-needed peace of mind during a challenging time. Disadvantages of a funeral trust fund. While funeral trust funds offer numerous advantages, they also have certain disadvantages. Irrevocability. Some funeral trust funds are irrevocable, meaning once they are established, they cannot be changed or revoked. You should fully understand the terms and conditions of the trust before setting it up. Costs and fees. Creating a funeral trust fund may involve attorney fees and other administrative costs. It's important to consider these expenses when deciding whether a funeral trust fund is the right choice for you. Alternatives to a funeral trust fund. If a funeral trust fund doesn't align with your circumstances, there are alternatives. Life insurance. A life insurance policy can provide funds for funeral and burial expenses. However, these funds may not be immediately accessible upon death, depending on the policy terms. Payable on death account. You could set up a payable on death account at your bank. Upon your demise, the funds in the account are directly transferred to the named beneficiary who can use them to cover funeral expenses. Planning for end-of-life expenses is an act of kindness towards your loved ones. A funeral trust fund can be an effective way to ensure your final wishes are respected and your loved ones are not burdened with unexpected expenses. However, setting up such a trust requires professional legal guidance to navigate complex laws and regulations. At Heritage Law Office, we can help you create a funeral trust fund that aligns with your needs and legal requirements. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching. A will is just one way to pass along your house. Joint ownership and revocable living trusts allow you to pass along your home, live in it while you're alive, and make sure your assets go where you want them to. Joint ownership and revocable living trusts are not necessarily replacements for a will. You should still create a will as a backup to carry out final wishes and pass along any other property that isn't in a trust or other probate avoidance. What is joint ownership? If you and your spouse or anyone else jointly own a house and the right of survivorship is included in that ownership, the house will automatically pass to the other individual upon your death without probate. Your spouse will be required to file paperwork to claim ownership. Wisconsin offers two types of joint ownership. Number 1, joint ownership, where 2 or more parties own an equal share. This works well for couples who acquire property together and each owns a half interest. However, this will not avoid probate for the remaining party or if the two parties were to die simultaneously. Number 2. Survivorship marital property, known in other states as community property, where the surviving spouse inherits any joint property. This does not include any property that's not part of the marital estate, such as anything kept as separate property. What does using a revocable trust mean? A revocable living trust is created while you're alive, and revocable because you can make changes as you wish as long as you're able to. This written document can be used for your house as well as other assets, such as bank accounts, other real estate, and vehicles. A minimum of 3 parties participate in a trust. The settlor or grantor who creates the trust, your spouse may also be a trustee. The trustee, the person or persons who accept the property from the trust and manage it according to the trust. That's you while you're alive, and whomever you assign after you die. You can have multiple co-trustees if you like. Beneficiaries are the individuals who receive income from the trust's property, and if directed, the property as well. There are advantages and disadvantages to both options. Joint ownerships and trusts are available to anyone but aren't a one-size-fits-all option. An experienced estate planning attorney who understands both can help you decide which one is right for your specific circumstances. Contact Heritage Law Office today for a free case evaluation.
Welcome to our comprehensive guide on estate planning. This presentation aims to provide you with essential knowledge to ensure peace of mind for you and your loved ones. Let's explore the key aspects of estate planning and how it can benefit you. Estate planning involves arranging for the management and disposal of your estate after death or incapacitation. It ensures your wishes are followed and helps minimize taxes, legal fees, and family disputes. Let's delve into why this process is crucial. Estate planning is vital as it protects your loved ones and assets. It helps avoid probate, designates guardians for minor children, and ensures healthcare decisions align with your values. Understanding these benefits is key to effective planning. An estate plan comprises several key components: a will, trusts, power of attorney, healthcare directives, beneficiary designations, and a letter of intent. Each plays a crucial role in ensuring your wishes are respected and executed properly. A will is a legal document specifying asset distribution. It appoints an executor and names guardians for children. However, it must go through probate, which can be time-consuming and costly. Understanding its role is essential in estate planning. Trusts help avoid probate and provide more control over asset distribution. They come in various types, including revocable, irrevocable, special needs, and charitable trusts. Each serves different purposes and offers unique benefits. A power of attorney, POA, appoints someone to handle financial and legal matters if you're incapacitated. A durable POA remains in effect after incapacity, ensuring your affairs are managed according to your wishes. Healthcare directives include a living will, which outlines end-of-life care preferences, and a healthcare proxy, which appoints someone to make medical decisions on your behalf. These documents ensure your healthcare wishes are respected. Beneficiary designations apply to life insurance, retirement accounts, and some bank accounts. They supersede your will, so it's crucial to keep them updated to reflect your current wishes and avoid unintended consequences. Estate taxes can significantly impact your estate's value. The federal estate tax threshold is $13.61 million as of 2025, but this is subject to change. Some states have their own taxes. Using trusts and gifting strategies can reduce tax liability. Avoid common estate planning mistakes: not having a plan, forgetting to update documents, ignoring digital assets, not considering long-term care, and choosing the wrong executor or trustee. Awareness of these pitfalls is crucial. Creating an estate plan involves several steps. taking inventory of assets and debts, identifying goals and priorities, choosing beneficiaries, drafting legal documents, and reviewing regularly. Each step is vital for a comprehensive plan. Update your estate plan during major life events, marriage, divorce, birth or adoption of a child, major asset changes, death of a family member, or changes in tax laws. Regular updates ensure your plan remains relevant and effective. Working with professionals can enhance your estate planning process. Consider consulting an estate planning attorney, financial advisor, tax professional, and trust officer. Their expertise can provide valuable insights and guidance. Final thoughts. Estate planning is not just for the wealthy. Start early and review regularly to protect what matters most, your people and your wishes. A well-crafted plan ensures peace of mind for you and your loved ones. We now open the floor for questions. For further assistance, please contact the Heritage Law Office. We're here to help you navigate the complexities of estate planning and ensure your wishes are honored.
One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer. A life estate allows you to transfer part ownership to your children or anyone else while you're alive. You can live in it or rent it out during your lifetime, and when you die, the remaining ownership passes to your kids or others to whom the asset was transferred, who may then take full possession and ownership of the assets. Placing the home in an irrevocable trust with your children as the beneficiaries is another option. Doing so may help you avoid estate taxes, qualify for Medicaid for nursing home or assisted living facility expenses, and protect the house from Medicaid estate recovery. Careful planning is a must, as making a transfer to an irrevocable trust may cause an ineligibility period for Medicaid for a period of time after such a transfer of your home. If the house is eventually sold, the proceeds remain in the trust, and the proceeds of the sale will be passed to the trust beneficiaries. If you gift a piece of real estate directly to your child or grandchild, it is perceived as a gift by the IRS. You cannot claim a loss, nor is your gift tax deductible. In this video, we will discuss how to set up a land trust, its benefits, and how it can protect your assets. What is a land trust? A land trust is a legal entity that allows you to manage and control real estate assets while keeping your ownership private. This can be particularly useful for safeguarding your assets from creditors, lawsuits, and other potential risks. With a land trust, you create a private agreement where a trustee holds the title to a property for the benefit of one or more beneficiaries. The main advantage of a land trust is that it allows the beneficiaries to retain control over the property while keeping their identities confidential. Key features of a land trust include privacy, control, and flexibility. The names of the beneficiaries are not disclosed in public records. Beneficiaries maintain control over the property, and they can transfer their interest in the trust without public record changes. What are the benefits of land trusts? People often choose a land trust is the privacy it offers. Since the trustee holds the title, the names of the beneficiaries are not listed in public records, making it difficult for potential litigants to identify the true owners. Additionally, by placing property in a land trust, it becomes more challenging for creditors to seize your assets. Creditors may find it difficult to discover the existence of the trust or determine the property's value, deterring legal actions and settlement negotiations. Land trusts also simplify the process of transferring property ownership. Beneficiaries can transfer their interest in the trust without triggering a public record, useful for estate planning and avoiding probate. How does a land trust work? To establish a land trust, you need to create a trust agreement that outlines the terms and conditions. This document identifies the trustee, beneficiaries, and the powers and responsibilities of each party. An experienced attorney should draft the trust agreement to ensure compliance with state laws. The trustee holds the legal title to the property and manages it according to the trust agreement, while beneficiaries retain control and direct the trustee on property management actions. While land trusts offer numerous benefits, they also have potential drawbacks. They provide limited asset protection compared to other entities like LLCs or irrevocable trusts. Setting up and maintaining a land trust can be complex and may require ongoing legal assistance. Additionally, there may be tax implications, so consulting a tax professional is essential. Integrating land trusts with other strategies. To maximize asset protection, consider integrating land trusts with other legal entities like LLCs, which combine privacy with liability protection. Irrevocable trusts and Medicaid asset protection trusts can also enhance asset protection. Common uses of land trust. Land trusts are popular among real estate investors for anonymous purchases, streamlined transactions, and avoiding due-on-sale clauses. They are also valuable for estate planning, asset management for high net worth individuals, and charitable giving. To create a land trust, consult with an experienced attorney, select a reliable trustee, draft the trust agreement, transfer the property title, and maintain the trust. Thank you for watching the video. If you found it helpful, please like and subscribe.
Here's a number that surprises most people. Roughly 2 out of 3 Americans die without a will. They don't intend to, they just never get around to it, and then it's too late. And when that happens, the state steps in and decides who gets everything you built. Not you, not your family, the state. What I'm about to walk you through is what actually happens to your home, your savings, and your kids if you die without a will. It's not what most people expect. And once you hear it, you'll understand why this is the most important paperwork you'll ever sign. So let's start with the basic question. If you die without a will, what happens to your stuff? Here's the honest answer. Your stuff doesn't just disappear, it goes to court. A process called probate. The state appoints someone to take an inventory of everything you own, pay your debts and taxes, and then distribute what's left. But here's the catch. The state isn't distributing your assets according to what you would have wanted. It's distributing them according to a rigid, one-size-fits-all formula called the laws of intestacy, which literally means dying without a will. And that formula often does not match what a real family would choose. Your stepchildren, your close friends, the charities you cared about, your long-term partner if you never married, under this formula, they may get nothing at all. Let's make this concrete, because this is where it gets personal. Say you own a home and have a life insurance payout sitting in savings, and you pass without a will. If you're married, your spouse doesn't automatically get everything. In many states, they get a share, and the rest is carved up among your children. If you have kids from a previous marriage, the state may divide your home between your new spouse and those children, creating a situation where your spouse must either buy out your kids, sell the family home, or share it with people they may not get along with. If you're unmarried but living with a partner, a very common situation, your partner inherits nothing unless the property is titled in both names. The entire estate may go to blood relatives you haven't spoken to in years. And if you have no relatives at all, the state can claim your entire estate. Everything you worked for goes to the government. Here's the part that keeps estate attorneys up at night, and it's the reason this video exists. If you die without a will and you have minor children, you have not named a guardian. That decision, who raises your kids if you're gone, does not get made by you. It gets made by a judge. The judge will consider family members, and sometimes the state will place your children with someone you would never have chosen. Your child's future is decided by a stranger in a courtroom, based on a formula, not on your wishes. You named a guardian in your mind 1,000 times, maybe your sister, maybe your best friend. But in your mind is not a legal document. If it's not written down, it doesn't exist. This is the single most important reason to have a will. Not for your money, for your children. A will is the only document that lets you choose who raises them. So by now you might be thinking, fine, I'll get a will. And you should. But here's the honest truth. A will is the foundation, not the whole house. A will does 3 essential things. It names your executor, it names a guardian for your kids, and it says who gets your assets. It's one of the most important documents you'll ever sign. But it does not automatically protect your home from nursing home costs. It does not automatically avoid probate. And it does not handle the 3 biggest threats to everything you've built. That's what this series is about. Over the next few videos, I'm going to show you the specific legal tools that protect your home and savings from the 3 things that drain family estates: nursing home costs, probate fees, and family conflict. You're watching video 1, the foundation. Get the will right, and the rest of the structure has somewhere to stand. Here's the thing I need you to hear, and I'll say it plainly. The best time to do this was years ago. The second best time is this week. I know it feels like a task for someday, but I've seen too many families learn the hard way that someday doesn't wait. The health crisis that lands you in a nursing home doesn't check your to-do list first. It doesn't wait until you've drafted your documents. It arrives on its own schedule, and if your plan isn't in place, it's too late for the tools that require planning in advance. That's the uncomfortable truth about estate planning. The most powerful protections, the ones that shield your home from the nursing home, the ones that keep your savings out of probate, have to be set up while you're healthy. Not in the middle of a crisis, before. So here's what I want you to take away. Without a will, the state decides who gets your home, your savings, and your kids. 2 out of 3 Americans never write one, and their families pay the price in court fees, conflict, and lost control. But a will is just the foundation. The real protection for your home and your life savings comes from the tools I'm going to show you next. If you want to make sure your family is protected, the first step is a conversation. Reach out to an attorney. Subscribe and turn on notifications so you don't miss the next video.
Think you're too young to need a will? If you're over 18 and have anything, like a bank account, car, or kids, it matters. Without a will, the law decides who gets what. And if you have children, the courts may choose who raises them. It might not be the person you'd want. Even a simple will gives you control over your assets and your wishes. It protects the people you care about, no matter your age or income. Waiting until you're older, that's one decision your family might pay for.
In a life estate, 2 or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder. The life tenant has full control of the property during his or her lifetime and has the legal responsibility to maintain the property as well as the right to use it, rent it out, and make improvements to it. When the life tenant dies, the house will not go through probate, since at the life tenant's death the ownership will pass automatically to the holders of the remainder interest. Because the property is not included in the life tenant's probate estate, it can avoid Medicaid estate recovery in states that have not expanded the definition of estate recovery to include non-probate assets. Even if the state does place a lien on the property to recoup Medicaid costs, the lien will be for the value of the life estate, not the full value of the property. If the property is sold, the proceeds are divided up between the life tenant and the remaindermen. The shares are determined based on the life tenant's age at the time. The older the life tenant, the smaller his or her share, and the larger the share of the remaindermen. Be aware that transferring your property and retaining a life estate can trigger a Medicaid penalty period if you apply for Medicaid within 5 years of the transfer. Purchasing a life estate should not result in a transfer penalty if you buy a life estate in someone else's home, pay an appropriate amount for the property, and live in the house for more than a year. If you have any questions regarding life estates or estate planning, contact the experienced attorneys at Heritage Law Office for a free consultation.
You won't believe how many families lose thousands just because of simple estate planning mistakes. Here are the top 5 you need to avoid. Mistake number 1, not having a will at all. Over 60% of adults don't have one. If you die without it, the state decides who gets your stuff, not you. Mistake number 2, forgetting to update beneficiaries. Your ex-spouse could inherit your life insurance just because you forgot to update a name. Seriously, this happens all the time. Mistake number 3, thinking a will avoids probate. It doesn't. A will still goes through court. To avoid that, you need a trust. Mistake number 4, not planning for incapacity. Who handles your finances or makes medical decisions if you're in a coma? If you don't name someone, the court will. And mistake number 5, DIY estate plans. One wrong word or signature could make your whole plan invalid. Saving a few bucks now could cost your family everything later.
Are you unsure whether a will or a trust is the best choice for your estate planning? In this video, we'll explore the key differences between wills and trusts to help you make an informed decision. First, let's talk about wills. A will is a legal document that outlines how you want your assets distributed after your death. It can include instructions for distributing personal property, naming guardians for minor children, and specifying funeral arrangements. One of the main advantages of a will is its simplicity and ease of creation. However, it's important to note that wills must go through the probate process, which can be time-consuming and public. Next, we have trusts. A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of beneficiaries. There are 2 main types of trusts: revocable and irrevocable. A revocable trust can be altered or dissolved by the grantor during their lifetime, offering flexibility and control. An irrevocable trust, on the other hand, cannot be easily altered once established, providing greater asset protection and tax benefits. Trusts generally bypass the probate process, offering privacy and potentially faster distribution of assets. When comparing wills and trusts, there are several factors to consider. Cost is one aspect. While wills are generally less expensive to create, trusts can save money in the long run by avoiding probate fees. Flexibility and control also vary, with wills being easier to amend, but trusts offering more control over asset distribution during your lifetime and after. Privacy is another significant difference. Wills become public record through probate, whereas trusts remain private. Additionally, the management and distribution of assets can be more streamlined with trusts, especially for complex estates. So, how do you choose the right option? Here are some questions to help you decide. What are your estate planning goals? If your primary goal is to ensure your assets are distributed quickly and privately, a trust may be the right choice. How do you feel about the probate process? Trusts can help your beneficiaries avoid the time-consuming and often costly probate process. Do you have minor children or dependents with special needs? Trusts can offer more control over how and when your assets are distributed, ensuring your children or dependents are cared for according to your wishes. What is the size and complexity of your estate? Larger estates might benefit more from the flexibility and control that a trust provides. Are you concerned about privacy? Trusts do not become public record like wills during the probate process. In conclusion, both wills and trusts have their unique advantages and can be tailored to meet your specific needs. It's always wise to seek professional legal advice to make an informed decision. Revocable trusts are often used to get the effects that most people are searching for when they get a will. Wills have an issue when compared to trusts in that, by law, they are routed through the probate process, which takes significant time and money. Probate is the legal process that occurs to your estate after you pass away. A properly designed and funded trust can completely avoid probate, bypassing the need for mandatory waiting periods, your information being publicly disclosed, and having the entire process monitored by a court. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. Here's how to avoid probate. If you pass away without proper pre-planning, your assets will likely go through probate. Probate is a court-supervised process for distributing your assets to your heirs. The process can be time-consuming and expensive, and it can tie up your assets for months or even years. What is probate? Probate is the legal process of distributing a deceased person's assets to their heirs. If the deceased person had a will, the court will follow the instructions in the will. If the deceased person did not have a will, the court will distribute the assets according to state law. The probate process can be time-consuming and expensive. It can also be stressful for the family members who are trying to settle the estate. The probate process can take months or even years to complete, and during that time, the assets of the estate are usually not available to the heirs. Why you should plan your estate to avoid probate. There are several good reasons to plan your estate to avoid probate. The probate process can be expensive. Probate can tie up your assets for a significant period of time. Probate is a public process, which means that anyone can access the documents filed with the court. If you don't want your assets to go through probate, you need to plan your estate carefully. There are several ways to avoid probate, including setting up a trust, transferring not go through probate when the trustor dies. Another way to avoid probate is to name a payable on death (POD) or transfer on death (TOD) beneficiary on eligible accounts. Assets that have a payable on death or transfer on death designee will not go through the probate process. Another way to avoid probate is to give away property during your lifetime. For example, you could give your assets to your children now instead of waiting until after you die. However, this may not be practical for everyone and may not have the best tax consequences for your children. Allowing your children to inherit assets allows them to benefit from a step-up in cost basis. Finally, some other estate planning tools, such as a life estate, may be available to avoid probate. There are many estate planning tools, each with their own uses. It is important to speak with an experienced estate planning attorney to find the proper tool for your individual situation. Thank you for watching this video brought to you by Heritage Law Office. If you found this information valuable and wish to learn more, don't forget to like, share, and subscribe to our channel for more insightful content.
Welcome back to our series on estate planning for business owners. In our last video, we introduced the importance of estate planning for your business. Today, we're going to focus on a critical component of that process, business succession planning. So, what exactly is business succession planning? Simply put, it's the process of preparing for the transfer of your business ownership and management to someone else when you retire, become incapacitated, or pass away. This plan ensures that your business can continue to operate smoothly and successfully, regardless of what the future holds. Business succession planning involves several key steps. Let's break them down. First, identify potential successors. This could be a family member, a key employee, a business partner, or even an outside buyer. The right choice depends on your business structure, your family situation, and your personal wishes. It's important to evaluate the skills, experience, and readiness of potential successors to ensure they can effectively take over the business. Second, develop a formal succession plan. This plan should outline the process for transferring ownership and management of the business. It includes legal documents, such as buy-sell agreements, that detail how the transfer will occur and under what conditions. The plan should also address the financial aspects of the transition, such as business valuation, funding mechanisms, and tax considerations. Third, prepare your successor. This involves training and mentoring the chosen individual to ensure they have the necessary knowledge and skills to lead the business. Gradually increasing their responsibilities can help them gain confidence and experience. This step is crucial to maintaining continuity and preserving the business's value. Fourth, communicate your plan. It's important to share your succession plan with key stakeholders, including family members, employees, business partners, and advisors. Open communication helps prevent misunderstandings and conflicts, ensuring everyone is on the same page regarding the future of the business. Why is business succession planning so important? Without a solid plan in place, the transition of your business can be chaotic and disruptive. It can lead to conflicts among family members or business partners, loss of key employees, and a decline in business value. A well-thought-out succession plan, on the other hand, provides stability and continuity, protecting your business's legacy and ensuring its ongoing success. Succession planning also has significant financial implications. Proper planning can help minimize taxes and other costs associated with the transfer of ownership. It can also ensure that your retirement is financially secure and that your heirs receive their fair share of the business's value. In summary, business succession planning is about preparing for the future and ensuring your business can thrive without you. It involves identifying potential successors, developing a formal plan, preparing your successor, and communicating the plan to all relevant parties. Thank you for watching. In our next video, we'll dive into the steps for creating a robust business succession plan. If you have any questions or need personalized advice, consult with a qualified estate planning attorney. See you in the next video.
How to save over $100,000 through Medicaid planning. Nursing home costs are expensive and add up quickly. Within a short period of time, an entire life savings can be depleted by paying for the cost of a stay in a nursing home. With proper planning, however, substantial value may be able to be preserved and passed along. Here is an example of how to save over $100,000 through active Medicaid planning. Mary has a savings account worth $75,000 and an investment account worth $150,000, totaling $225,000. Mary will be requiring nursing home care starting next month. Nursing home expenses are $10,000 per month. Since Mary did not previously buy long-term care insurance or pre-plan, Mary will have to cover the costs out of pocket. Mary will have to pay out of the savings account and liquidate the investment account to pay for nursing care. In less than 2 years, Mary will be completely out of money. Medicaid is administered by states according to federal requirements. State rules may vary. For example, in Wisconsin, the Medicaid rules are structured so that once you have less than $2,000 in assets, Medicaid will pay for a required nursing home stay. Now that Mary has spent $225,000 and is out of money, public benefits will pay for Mary's nursing home care. Most people struggle with the concept of seeing their entire life savings depleted very quickly. They would prefer to transfer those assets to their children, family members, friends, or donate that money to charity, rather than seeing the money depleted. The easy solution seems to be to give away all your assets to drop below the asset limit and qualify for Medicaid. It is not that easy. Medicaid will not allow you to gift away all your assets and immediately qualify for Medicaid benefits. When gifting assets, Medicaid imposes a divestment penalty, causing an ineligibility period for Medicaid, time that must pass before public benefits will pay for nursing home expenses. The larger the value of the gift made, the longer the ineligibility period. The ineligibility period only starts counting down when you apply for Medicaid, and you would be otherwise eligible if the ineligibility period did not exist. At the time of this video, in Wisconsin, for every $303.38 given away, 1 day of Medicaid ineligibility is assessed. If Mary were to give away all her money, then apply for Medicaid, she would be ineligible for 2 years after applying and must find funds to pay for nursing home expenses. Here's one possible way to solve this issue. Again, there are different rules in different states, so be sure you talk to a professional. Mary has a total of $225,000. Mary splits the money into 2 different pieces. One that Mary keeps and turns into a stream of income, and one that Mary gives away to her family, friends, or charity. In this example, Mary converts $118,000 to a stream of monthly income, income is treated differently than assets and do not count towards the Medicaid asset limit in Wisconsin. Mary receives the money back in equal payments over 12 months as income. We will discuss what Mary does with this cash flow in just a bit. Mary also gives away the remaining $107,000, either to individuals or to a special type of trust, an irrevocable trust. We believe an irrevocable trust is generally a better option for numerous reasons, which we will discuss in a separate video. At this point, Mary has no money remaining. She has gifted $107,000 to family, friends, or a trust, and has spent $118,000 to acquire a monthly income stream. Giving away money is considered a gift, causing a divestment period where Mary is ineligible for Medicaid benefits for a period of time. In Mary's scenario, a gift of $107,000 will cause an ineligibility period of 352 days. Now that Mary has less than $2,000, Mary can apply for Medicaid. Mary will be assessed an ineligibility period due to the $107,000 gift. However, the ineligibility period will now start counting down, and Mary will be eligible for coverage at the end of the 352-day ineligibility period. During the ineligibility period, Mary will use the monthly income stream to pay the nursing home expenses. That stream of income will expire the same time as Mary's ineligibility period, leaving Mary with less than $2,000 during the ineligibility period and when the ineligibility period ends. At the end of the ineligibility period, the income stream will stop, and Medicaid will cover Mary's nursing home expenses. Meanwhile, the assets that are set aside in the trust or gifted to individuals are saved. They are not subject to being spent on nursing home expenses. Rather than spending $225,000 on nursing home expenses and having the entire value of the assets depleted, $107,000 were able to be passed on to friends, family, or charity. Our next video will be about how Mary could have saved almost all of the $225,000 with proper Medicaid pre-planning. Medicaid planning and Medicaid applications are complicated, precise, and vary state to state. One mistake can be very costly. Contact one of our attorneys to make sure your assets are properly protected. A special needs trust is a type of trust that gives an individual with special needs access to funds in the trust without losing benefits provided by public assistance programs. Public assistance programs set up for people with special needs are generally predicated on income and asset limitations. The limitations may be surprisingly low in your state. However, money or assets that belong to the Special Needs Trust generally do not count toward the purpose of qualifying for public assistance. By properly setting up and funding a Special Needs Trust for the individual with special needs, they will have additional funds from the trust while still qualifying for public benefits. Improperly setting up or funding a special needs trust will generally result in loss of assets or loss of public benefits. Consult with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional. A revocable living trust has many benefits over a will, which may make placing your house in a trust a wise decision. For example, to administer a will, it is necessary to initiate a court procedure known as probate. Probate can be a cumbersome and time-consuming process. However, a properly designed revocable living trust has the luxury of being administered in the privacy of your own home or your attorney's office, rather than in the courtroom. This process is private, quicker, and oftentimes significantly less expensive compared to probate. A revocable living trust can avoid the probate process, saving time and money. If you own property in multiple states, such as Minnesota and California, a revocable living trust becomes even more valuable. With a revocable living trust, you will not have to open multiple probates across the different states. Moving your house to a revocable living trust is beneficial in most circumstances. This often raises the question, will a transfer of my home to a trust protect my home from creditors or nursing home expenses? With a revocable living trust, the answer is no. However, another type of trust, an irrevocable trust, may be able to provide you with protection for your home. Moving the house to an irrevocable trust has the result of removing it from your estate. This means it is no longer your asset from a legal standpoint. The house is owned by the irrevocable trust itself, similar to how a corporation can own an asset. Since you no longer own or have control of the asset, the home may be able to be protected from creditors or if you want to apply for Medicaid. Both revocable and irrevocable trusts are important parts of proper estate planning. However, for trusts to function, they must be used and set up properly. Improper use can have a substantial negative effect on your estate. Contact one of our attorneys to make sure your assets are properly protected.
In our last video, we discussed funeral trusts and spend-down strategies for nursing home care and Medicaid eligibility. Today, we're going to explore an important aspect of Medicaid planning, the look-back period and potential penalties. When you apply for Medicaid, there's a financial review process called the look-back period. This is a span of 5 years during which Medicaid examines your financial transactions to ensure you haven't transferred assets solely to qualify for Medicaid. The purpose is to prevent people from giving away their money or property just to meet Medicaid's asset limits. During this 5-year window, Medicaid looks at any gifts, transfers, or sales of assets you've made. If they find that you've transferred assets for less than fair market value, these transactions may trigger penalties. For example, if you gifted a significant amount of money to a family member within the look-back period, Medicaid may impose a penalty period during which you are ineligible for benefits. Penalties for violating the look-back period rules involve a waiting time before you can receive Medicaid coverage. The length of this period depends on the amount of money or value of assets transferred. Medicaid calculates how long the amount transferred would have paid for your care, and that duration becomes your penalty period. So, how can you avoid these penalties? First, early planning is crucial. Start planning for long-term care and Medicaid well before you need it. This gives you time to arrange your finances in a way that complies with Medicaid rules. Second, be aware of the types of transactions that can trigger penalties. Large gifts, property transfers, and sales for less than market value within the look-back period can all lead to penalties. It's essential to document any transactions and understand their potential implications. Third, consider working with a qualified attorney who has experience in elder law and Medicaid planning. They can help you navigate the complex rules and develop a strategy that minimizes penalties while protecting your assets. Let's look at a couple of real-life examples. Imagine someone who transferred a large sum of money to their children 2 years before applying for Medicaid. This transfer would likely trigger a penalty period, delaying their eligibility for Medicaid benefits. On the other hand, someone who planned ahead and set up an irrevocable funeral trust 5 years in advance would have those funds exempt from the look-back review, avoiding penalties. Even if you haven't planned 5 years in advance, there are still ways to protect some of your funds. Consulting with an experienced attorney can help you explore options like partial asset protection and other strategies tailored to your specific situation. In summary, understanding the Medicaid look-back period and its penalties is vital for effective Medicaid planning. By starting early, avoiding questionable transactions, and seeking professional guidance, you can protect your assets and ensure you're prepared for future long-term care needs. Thank you for watching. If you have more questions or need personalized advice on Medicaid planning and the look-back period, consult with a qualified attorney to explore your options. Welcome to our series on franchise law. Today, we're discussing the legal aspects of buying or starting a franchise. Understanding these aspects is crucial for making informed decisions and ensuring your business venture is successful. First, what is a franchise? A franchise is a business model where a franchisor grants a franchisee the right to operate a business using the franchisor's brand, products, and systems. The franchisee pays fees and agrees to operate the business according to the franchisor's guidelines. When considering a franchise, there are two primary legal documents you need to be familiar with: the Franchise Disclosure Document, or FDD, and the Franchise Agreement. The Franchise Disclosure Document, or FDD, provides detailed information about the franchisor and the franchise system. It includes the franchisor's history, litigation history, financial statements, initial and ongoing fees, and obligations of both parties. Reviewing the FDD thoroughly is essential. The franchise agreement is the binding contract between the franchisor and franchisee. It outlines the terms and conditions of the franchise relationship, including the rights and responsibilities of each party. Key terms to understand include the duration of the franchise, renewal terms, territorial rights, and conditions for termination. Conducting thorough due diligence is critical before buying a franchise. This involves reviewing the FDD, researching the franchisor's history and reputation, and understanding the financial commitments and projections. When buying a franchise, there are several legal considerations to keep in mind: initial franchise fees and ongoing royalties. Understand the total cost involved. Territorial rights and restrictions. Know your exclusive territory and any restrictions. Intellectual property rights. Understand your rights to use the franchisor's trademarks and proprietary systems. Obligations of the franchisor and franchisee. Clarify the support and training provided and expected. Renewal and termination clauses. Pay attention to the terms for renewing or terminating the agreement. Starting a franchise involves several key steps. Ensure legal compliance by registering your franchise and adhering to state-specific regulations. Develop an operations manual outlining how the franchise should be run. Protect your intellectual property by securing trademarks and trade secrets. Financial aspects are important. Explore financing options for buying or starting a franchise and understand the initial investment required, as well as ongoing expenses and royalties. Franchisee support and training are vital for success. Most franchisors provide initial training and ongoing support to help franchisees run their businesses effectively. Take full advantage of these resources. Disputes can arise in any business relationship. Common disputes in franchising include disagreements over territory, fees, and performance standards. Methods for resolving disputes include mediation, arbitration, and litigation. Address disputes promptly and seek legal advice if necessary. In conclusion, buying or starting a franchise involves navigating several legal aspects, from understanding the FDD and franchise agreement to conducting due diligence and ensuring legal compliance. Consulting with a qualified franchise attorney is essential to protect your interests and make informed decisions. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified franchise attorney. See you in the next video.
You may ask, why should I avoid probate? The answer is simple: time and money. The probate process can be cumbersome and take significant time and money. However, the probate process can be avoided. Trusts, when properly set up and funded, can avoid probate. The question is, does a will avoid probate? No. Assets controlled by a will do not avoid probate. A will by its nature directs the assets through the probate process for administration and ultimate distribution to the beneficiaries. There are a number of ways to avoid probate. First, you can give away all your money and assets, so you have nothing to pass along. Second, you can add a joint owner to your assets or add a payable or transfer on death designee to your accounts. Third, you can establish a life estate on your property. Finally, you can avoid probate with a trust. Adding a joint owner or adding a payable or transfer on death designee is a simple solution. However, they do not offer the same benefits as a trust. Adding a joint owner or adding a payable on death or transfer on death designee does not offer asset protection for beneficiaries, can potentially cause a loss of government benefits for a beneficiary with a disability or special needs, and does not help with potential future incapacity. With a life estate, you do not own entire interest in the property. The interest in the property is split into two pieces: the current interest and the interest the other owner, the remainderman, has after your passing. Additionally, if you wish to sell the property, you can only sell the portion you own, your life estate, and you would need permission from the remainderman to sell the entire interest. A properly set up and funded trust can solve these issues. A trust can give possible asset protection for beneficiaries. With a trust, you can retain control of assets. A trust has the ability to protect beneficiaries with disabilities or special needs. Finally, a trust can plan for incapacity. The only downside of a trust is the initial setup. To ensure your will or trust is set up properly, contact Heritage Law Office today.
Own rental property. Here's why many investors put rentals in a trust. First, to skip probate. When you pass, property in a revocable living trust can go straight to your beneficiaries, faster, private, and with less cost. Second, to protect your privacy. Title held by a trust keeps your name off public ownership records. Third, for seamless management. If you're incapacitated, a successor trustee can step in to collect rent and handle repairs. What about asset protection? A revocable trust won't shield you from creditors, but some irrevocable trusts can offer protection and help with Medicaid planning. Taxes. With a revocable trust, you keep simple reporting now, and your heirs may receive a step-up in basis at death, reducing capital gains. Have an LLC? Let the trust own the LLC to combine liability protection with estate planning benefits. Got a mortgage? Review the loan and talk to your lender before transferring. Some moves to revocable trusts are allowed under federal law.
Have you ever wondered what happens to someone's assets after they pass away? Today, we'll explore the world of probate, breaking it down into steps, as well as looking into the various types that are most appropriate depending on your circumstances. Dealing with assets after a loved one's passing is never easy, but understanding the process can help. Let's break down probate. What is probate? Probate is the formal legal procedure after someone's death, which settles their financial and legal affairs. It is the process that ensures assets are transferred rightly and legally to beneficiaries, and any outstanding debts are settled. But who ensures this process runs smoothly? The crucial role of the executor, that would be the executor, also known as the personal representative. They initiate the probate process, manage assets, settle debts, and ensure the rightful distribution of assets. It's a significant role, oftentimes demanding guidance from experienced probate attorneys. But how do you get started with probate? Let's walk through it step by step. Step 1. Initiating the probate process. Everything begins with appointing a personal representative, either named in the will or chosen by the court. They file a petition for probate, and here, professional legal guidance can be invaluable. Step 2. Inventorying the estate. The representative then takes stock of the deceased's assets, everything from real estate to bank accounts. Step 3. Settling debts and taxes. Before beneficiaries get anything, all debts and taxes must be settled using the estate's assets. Step 4. Distribution. Finally, the remaining assets are distributed according to the will or state laws if there's no will in place. Probate isn't one size fits all. There are different types for varying circumstances. Types of probate. Formal probate. This structured, judge-overseen process is ideal for complex estates or when beneficiaries have disputes. Informal probate. A simpler, quicker process fit for straightforward estates with a valid will and no disputes. Special administration. This method is for when immediate action is required or when full estate administration isn't necessary. Probate may seem complex, but with experienced guidance, you can be sure your estate is managed properly. Be sure to check out additional articles on probate or inquire about a consultation on the Heritage Law Office website in the description below. Also, don't forget to subscribe to the channel for more helpful legal content, and please hit that like button. In this video, we will discuss the benefits of a living trust and how it can be a powerful tool in your estate planning strategy. A living trust, also known as a revocable trust, allows you to manage your assets during your lifetime and dictate how those assets will be distributed after your death. One of the key benefits of a living trust is avoiding probate. Probate is the legal process of distributing a deceased person's assets under court supervision. By placing your assets in a living trust, you can ensure a smoother, quicker distribution to your beneficiaries, saving time, reducing costs, and maintaining privacy. Another significant advantage is the control a living trust provides over your assets. You can manage your assets during your lifetime and specify exactly how and when your assets will be distributed after your death. This flexibility allows you to tailor the distribution to meet your beneficiaries' needs, such as staggering distributions for younger heirs. A living trust also includes provisions for managing your affairs if you become incapacitated. If you are unable to manage your assets due to illness or injury, your successor trustee can step in without the need for a court-appointed conservatorship, ensuring continuous management of your affairs. Flexibility is another key benefit of a living trust. You can amend or revoke the trust at any time while you are alive and competent, allowing you to adapt your estate plan as circumstances change. While a living trust alone does not provide estate tax benefits, it can be part of a comprehensive estate plan designed to minimize estate taxes. By integrating strategies such as irrevocable trusts or gifting, you can reduce the taxable value of your estate. A living trust can also protect your beneficiaries. This is especially beneficial for minors, individuals with special needs, or those who may struggle with financial management. Special needs trusts and spendthrift provisions within a living trust can ensure that your beneficiaries are protected and their inheritance is managed wisely. For business owners, a living trust can streamline the transfer of business ownership, ensuring a smooth transition and continuity of operations. This helps prevent disputes and ensures the business continues to operate effectively. Finally, administering an estate through a living trust is generally simpler and less burdensome for your trustee compared to probate. This results in lower administrative costs and a more straightforward process for managing and distributing your assets. In summary, a living trust offers numerous benefits, including avoiding probate, maintaining control over your assets, managing incapacity, flexibility, reducing estate taxes, protecting beneficiaries, streamlining business succession, and simplifying estate administration. In this video, we'll talk about what is Medicaid planning and why is it important. Medicaid planning is an essential aspect of estate planning, ensuring that individuals can receive the long-term care they need without exhausting their financial resources. With the help of an experienced attorney, you can navigate the complex regulations surrounding Medicaid eligibility and develop a strategy that protects your assets while securing your future care needs. Understanding Medicaid planning. Medicaid planning involves analyzing an individual's financial situation and employing strategies to qualify for Medicaid benefits while preserving their assets. It is crucial because the cost of long-term care can quickly deplete an individual's life savings. You may wonder, what are Medicaid eligibility requirements? Applicants must meet specific income and asset limits. These limits vary based on factors like age, disability status, and household size. An experienced attorney can help you understand these requirements and determine the best approach to qualify. Here are some strategies for Medicaid planning. There are several strategies available for effective Medicaid planning. Some of these include asset transfers. Transferring assets to family members or into trusts can help you meet Medicaid's financial eligibility requirements. However, it is essential to execute these transfers strategically to avoid penalties. Here's how irrevocable trusts can help. Irrevocable trusts can protect your assets from being counted toward Medicaid eligibility. By placing assets in an irrevocable trust, you effectively relinquish control over them, ensuring they are not considered when determining eligibility. This is how annuities can help. Instead of annuities, converting assets into an income stream through annuities can help meet Medicaid's financial requirements. An experienced attorney can help you determine if an annuity is appropriate for your situation. The importance of Medicaid planning. Medicaid planning is crucial for several reasons, such as protecting assets. Proper planning ensures that your assets are protected from the high cost of long-term care, allowing you to pass on your legacy to your loved ones. Medicaid planning also provides access to quality care. Qualifying for Medicaid benefits guarantees access to quality long-term care services when you need them, without the burden of high out-of-pocket costs. Also provides peace of mind. Knowing you have a plan in place for your long-term care needs provides peace of mind for you and your family. Now we will talk about the role of an attorney in Medicaid planning. An experienced attorney plays a critical role in Medicaid planning, offering the following benefits. Experienced guidance. An attorney can help you navigate the complex rules and regulations surrounding Medicaid, ensuring you understand your options and make informed decisions. Customized strategies. Every individual's situation is unique. An attorney can develop a personalized plan that meets your specific needs and goals. Ongoing support. As your situation evolves, an attorney can help you adjust your Medicaid planning strategy to ensure continued eligibility and asset protection. In conclusion, Medicaid planning is an indispensable component of estate planning that aims to secure quality long-term care without jeopardizing your financial well-being. With the guidance of Heritage Law Office, you'll have an experienced attorney to navigate the complex regulations and eligibility requirements. Whether it's through asset transfers, the establishment of irrevocable trusts, or annuities, our tailored strategies offer asset protection, quality care, and peace of mind for you and your loved ones. If you have any questions, please leave a comment and we'll try to answer them. Don't forget to like and subscribe for more helpful content like this. Thank you for watching.
Gift tax? Most people get this completely wrong. Let me break it down with 2025 rules. The IRS lets you give someone up to $19,000 in 2025 without triggering gift tax. Sounds like a lot? You can do that for each person you gift. And if you're married and use gift splitting, you and your spouse can each give $19,000. That's $38,000 per recipient. No tax. What about bigger gifts? Here comes the lifetime exemption. In 2025, it's $13.99 million per person. That covers gifts plus your estate. That means if you exceed the annual $19,000, you probably still won't owe tax. You'll just use up part of your lifetime exemption. But you may need to file IRS Form 709 to report it. Smart strategies people use. Spread out gifts over years so you stay under the annual limit per person. Pay tuition or medical costs directly to the institution. Those are still fully exempt. Gift appreciating assets early, like stocks or real estate. So future growth happens outside your taxable estate. Heads up, starting January 1st, 2026, the One Big Beautiful Bill Act permanently raises the lifetime exemption to $15 million per person and $30 million for married couples, indexed for inflation. So here's the punch. With smart planning, you can give generously, without gift tax drama. Most people think once they've written a will, they're done. But here's the biggest mistake. They never update it. Life changes, fast. Got married, had a child, got divorced, bought a house. All of these are reasons to review your will. An outdated will can cause confusion, delays, or even get challenged in court. Set a reminder to check your will every few years, or any time your life changes. It's a simple habit that can save your family a lot of stress later.
Thinking about how to protect your assets and make life easier for your loved ones? A revocable trust might be the answer. A revocable trust lets you transfer ownership of your assets, like your home and bank accounts, into a trust while keeping full control. You can buy, sell, or move assets in and out of the trust just like always. And since it's revocable, you can change or cancel it anytime you want. One major benefit? Avoiding probate. It's the court process that can be time-consuming and expensive when someone dies with just a will. With a revocable trust, your assets pass directly to your beneficiaries, meaning less hassle and more privacy for your loved ones. Plus, if you become incapacitated, you can name a successor trustee to manage your affairs, avoiding confusion and family conflict.
I'm healthy, I eat kale, so I don't need estate planning, right? Wrong. You need a power of attorney. Yesterday. If you get in an accident or end up in the hospital and can't speak for yourself, no one can legally help you. Not your partner, not your mom, not your best friend. Without a power of attorney, they might not even be allowed to talk to your doctor. Imagine this. You're unconscious, your bills are due, your pet needs food, your life is on hold. But with a power of attorney, your person can pay your bills, talk to your doctors, and keep things moving. Without it, they might have to go to court just to help you. And that takes time, money, and a whole lot of stress. So listen, you don't need to be old. You need to be prepared. Power of attorney. Get it, sign it, store it, because adulting means protecting your future. Do you actually need a power of attorney? Or is it just something lawyers try to sell you? Here's the truth. If you become incapacitated tomorrow, who pays your bills? Who makes your medical decisions? Without a power of attorney, your family has to go to court. That process can take months and cost thousands. A power of attorney lets someone you trust step in immediately. No court, no delays. So ask yourself, do you have assets, a family, a business? Are you over 18 years old? Then yeah, you probably need one. Drop a comment if you've set yours up or tell me what's holding you back.
In this video, we will discuss what a trust is and how it works. A trust is a legal arrangement where one party, known as the grantor, transfers assets to another party, called the trustee. The trustee holds and manages these assets for the benefit of a third party, known as the beneficiary. There are several types of trusts, each serving different purposes. The most common types are revocable trusts and irrevocable trusts. A revocable trust can be altered or revoked by the grantor during their lifetime. This flexibility allows you to make changes as your circumstances or intentions evolve, making it an excellent choice for those who want to retain control over their assets. An irrevocable trust, on the other hand, cannot be easily changed once it is established. This type of trust can provide significant tax advantages and protect assets from creditors, making it ideal for those looking to secure their wealth for future generations. Special purpose trusts are designed for specific goals. Let's look at some common examples. A charitable trust can help you support a cause you care about while potentially offering tax benefits. A special needs trust can provide for a loved one with disabilities without jeopardizing their eligibility for government benefits. A spendthrift trust is useful for protecting a beneficiary who may not be financially responsible. A Medicaid Asset Protection Trust helps individuals qualify for Medicaid while protecting their assets. A testamentary trust is established through a will and goes into effect upon the grantor's death. An asset protection trust is designed to protect your assets from creditors. Creating a trust involves drafting a legal document that outlines the terms of the trust and appointing a trustee. Once established, the grantor transfers assets into the trust, which the trustee then manages according to the trust's terms. The trustee has a fiduciary duty to act in the best interests of the beneficiaries, ensuring the assets are managed and distributed as specified in the trust document. Using a trust offers several benefits. It can help avoid the lengthy and public probate process, ensuring a quicker and more private transfer of assets. Trusts also provide greater control over how and when assets are distributed, which can be particularly useful for beneficiaries who are minors or have specific needs. Additionally, certain types of trusts may offer tax advantages, potentially reducing the overall tax burden on the estate. In summary, trusts are versatile legal tools that can provide significant benefits in estate planning.
Imagine you're one of the highest paid people on the planet, making $1,000 an hour. Sounds amazing, right? But let's see how far that really gets you. You work 10 hours a day, raking in $10,000 daily. Do that every day for a year, and you've made about $3.65 million. But wait, let's stretch this out. If you keep this insane pace for 40 years, you'll make around $146 million before taxes. But here comes the tax man. Assuming 40% goes to taxes, you're left with roughly $87 million after 4 decades of hard work. Here's the kicker. You work at 10 hours every single day for 40 years. And after all that, you'd still only have about 8.7% of $1 billion. Not even close to billionaire status. Remember, it's not just about how much you earn, it's about how much you keep. The wealthiest rely on smart tax planning and strategies to protect their legacy. So next time you hear about billionaires, remember, even if you made $1,000 an hour for decades, you'd barely make a dent. Billionaire money is about ownership, leverage, and scaling wealth beyond any salary.
An estate plan is a collection of legal documents and strategies that outline how your assets and affairs will be handled in the event of your death or incapacity. Key components of an estate plan include wills, trusts, powers of attorney, and healthcare directives. There are several compelling reasons to have an estate plan. First, it ensures that your wishes are followed regarding the distribution of your assets and care of your dependents. Second, it protects your assets from unnecessary taxes, expenses, and legal fees. Third, it provides for your family by outlining your intentions clearly, reducing stress and uncertainty for your loved ones. Without an estate plan, your estate may face significant legal complications and delays. This can lead to increased costs and taxes, reducing the inheritance you leave behind. Additionally, the absence of clear instructions can result in family disputes and conflicts over your estate. Starting an estate plan involves several key steps. Begin by taking inventory of your assets, including property, investments, and personal belongings. Decide on your beneficiaries and how you want your assets distributed. Next, consult with an experienced attorney to draft the necessary legal documents, such as a will or trust. Regularly review and update your estate plan to reflect changes in your life, such as marriage, divorce, or the birth of a child. An estate plan isn't just about distributing your assets. It also includes making decisions about your healthcare and financial affairs if you become incapacitated. Powers of attorney and healthcare directives allow you to appoint someone you trust to make decisions on your behalf, ensuring your wishes are respected. Having an estate plan is crucial for ensuring your wishes are respected and your family is protected. Don't wait until it's too late. Contact an attorney to start your estate plan today. This proactive step can provide peace of mind and security for you and your loved ones. Thank you for watching. Make sure to like and subscribe for more. A trust is a legal document that acts like a bucket to hold assets and contain a set of rules and instructions. The person in charge of that bucket is called the trustee. There are several types of trusts, such as a revocable trust, an irrevocable trust, a pet trust, a charitable remainder trust, and more. An irrevocable trust is a type of trust that cannot be modified, amended, or terminated without the permission of the grantor's beneficiary or beneficiaries. The grantor can give assets to the irrevocable trust. Doing this makes the irrevocable trust the owner of the assets and removes the grantor as the owner of those assets. The assets no longer belong to the grantor from a tax, estate recovery, and Medicaid perspective, allowing for advanced estate planning techniques. Irrevocable trusts are complicated and should be created by a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional.
To date, we're going to talk about a topic that many might overlook: funeral trusts. A funeral trust is a legal arrangement you set up in advance to cover your funeral expenses. It ensures that the money you set aside will be used specifically for your funeral costs, alleviating financial and emotional stress for your family during a difficult time. A funeral trust is a financial arrangement in which funds are set aside to pay for your future funeral and burial expenses. This trust can be revocable, meaning you can change or cancel it, or irrevocable, meaning once it's set up, it can't be altered or revoked. So why consider a funeral trust? Here are a few key benefits. Number 1. Financial protection. Funeral trusts can help protect your assets from being used for other purposes. This is especially important for individuals seeking to qualify for Medicaid, as funds in an irrevocable funeral trust are typically exempt from asset limits. Number 2. Peace of mind. Knowing that your funeral expenses are covered provides peace of mind for both you and your loved ones. It's one less thing for your family to worry about during a time of grief. Number 3. Cost control. By setting up a funeral trust, you can lock in current prices for funeral services, protecting you from inflation and rising costs over time. Now, let's talk about how to set up a funeral trust. There are a few key steps to follow. First, consult with a professional. Work with a qualified attorney or financial advisor to understand your options and ensure the trust is set up correctly. Next, choose a funeral provider. Select a funeral home or provider and decide on the services you want. This could include everything from burial or cremation to specific types of services and merchandise. Then, fund the trust. Transfer the funds into the trust. The amount you deposit will depend on the estimated cost of your chosen funeral services. Before setting up a funeral trust, here are a few important considerations. Firstly, decide whether a revocable or irrevocable trust is best for your situation. Each has its advantages and limitations. Secondly, understand that funeral trust laws vary by state, so it's crucial to be aware of the regulations in your area. Finally, choose a reliable trustee who will manage the funds and ensure they are used appropriately when the time comes. While it's a difficult topic to think about, setting up a funeral trust is a thoughtful and practical step that can provide significant benefits. It's about planning ahead and making sure your final wishes are honored without placing a financial burden on your loved ones. Thank you for watching. If you have more questions or need guidance on setting up a funeral trust, consult with a qualified attorney to explore your options. Welcome to our series on starting a business. Today, we're going to discuss the key legal steps you need to take when starting a new business. Understanding these legal considerations is crucial for ensuring your business operates smoothly and is set up for success. First, let's talk about choosing the right business structure. The most common structures are sole proprietorship, partnership, limited liability company, or LLC, and corporation. Each structure has different implications for liability, taxes, and management. A sole proprietorship is the simplest form but doesn't provide personal liability protection. An LLC offers liability protection and flexible tax options, making it a popular choice for small businesses. Corporations provide the most liability protection but come with more regulatory requirements. Next, you need to register your business. This involves choosing and registering your business name, often called a DBA, or doing business as. You'll need to file the necessary paperwork with your state and local authorities. Obtaining the necessary licenses and permits is another key step. The requirements vary depending on your business type and location. For example, a restaurant may need health permits, while a construction company may need specific contractor licenses. Research the licenses and permits required for your business and apply for them before you start operating. Understanding your tax obligations is essential. Start by obtaining an Employer Identification Number, or EIN, from the IRS. This number is used for tax filings and other business activities. You should also understand your obligations for sales tax, payroll tax, and income tax. Consulting with a tax advisor can help ensure you meet all your tax responsibilities. Creating a business plan is both a strategic tool and a legal consideration. A comprehensive business plan includes an executive summary, market analysis, and financial projections. It helps guide your business decisions and can be crucial for securing financing. Setting up your business finances is important. Open a business bank account to keep your personal and business finances separate. Set up accounting and bookkeeping systems to track your income and expenses accurately. Understanding your business insurance options is also important. Insurance can protect your business from various risks, such as liability claims and property damage. Employment law considerations are crucial if you plan to hire employees. Understand the difference between hiring employees and independent contractors. Comply with employment laws regarding wages, benefits, and workplace safety. Creating employment contracts and an employee handbook can help outline expectations and legal requirements. Protecting your intellectual property is vital. This includes trademarks, copyrights, and patents. Register your intellectual property to prevent others from using your brand or products without permission. Drafting key contracts and agreements is essential for legally binding business relationships. This includes partnership agreements, client contracts, and supplier agreements. Having clear, written agreements helps prevent disputes and outlines each party's responsibilities. Compliance with industry regulations is critical. Each industry has specific regulations that businesses must follow. Ensure you understand and comply with these regulations to avoid legal issues. Seeking professional advice is highly recommended. Consulting with legal, financial, and business advisors can help ensure you're taking the right steps. In conclusion, starting a business involves several key legal steps: choosing the right business structure, registering your business, obtaining necessary licenses, understanding tax obligations, creating a business plan, setting up finances, complying with employment laws, protecting intellectual property, drafting key contracts, and ensuring industry compliance. Taking these steps will help you build a solid legal foundation for your business. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you.
Are you confused about estate planning terms? Stay tuned because we're about to simplify them for you. If you find this information helpful, make sure to subscribe to our channel for more tips on estate planning. What is a will? Let's dive right into it. A will is a legal document that outlines how your assets will be distributed after your death. It's a crucial part of estate planning because it ensures that your property is distributed according to your wishes. Additionally, if you have minor children, a will can specify who will take care of them. In summary, a will is essential for outlining how your assets are distributed and who will take care of your minor children. Next up, what is a trust? A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. There are two main types of trusts: revocable and irrevocable. A revocable trust can be altered or terminated by the grantor during their lifetime, while an irrevocable trust generally cannot be changed once it's established. People often set up trusts to avoid probate, reduce estate taxes, and manage their assets during their lifetime and beyond. Power of attorney. Have you ever wondered what a power of attorney is? A power of attorney is a legal document that grants someone else the authority to act on your behalf in financial or legal matters. This person is known as your agent or attorney, in fact. There are different types of powers of attorney, including a durable power of attorney, which remains in effect if you become incapacitated, a springing power of attorney, which comes into effect upon certain circumstances, a financial power of attorney, which specifically covers financial decisions, and a medical power of attorney, which specifically covers medical decisions. Now, let's talk about beneficiary designation. A beneficiary designation is a legal mechanism for naming individuals or entities to receive certain assets upon your death. Common assets that have beneficiary designations include life insurance policies, retirement accounts, and bank accounts. Beneficiary designations are important because they can override your will, so it's crucial to keep them up to date. Healthcare directive. Finally, what is a healthcare directive? A healthcare directive, also known as a living will or advance directive, is a legal document that specifies your wishes regarding medical treatment if you become unable to communicate those decisions yourself. It typically includes instructions on life-sustaining treatments and end-of-life care. Having a healthcare directive ensures that your medical care preferences are known and respected. These are just a few key estate planning terms, but they form the foundation of a comprehensive estate plan. Understanding these terms can help you take control of your future and protect your loved ones. In this video, we will discuss how to amend a living trust including the reasons for making amendments and the steps involved in the process. A living trust, also known as a revocable trust, is a legal document created during a person's lifetime that designates a trustee to manage the individual's assets for the benefit of the beneficiaries. One of the main advantages of a living trust is that it allows for the easy transfer of assets without the need for probate. There are several common reasons why you might need to amend a living trust. You may need to add or remove beneficiaries due to marriage, birth of children, or death. You might want to appoint a new trustee or successor trustee. Perhaps you need to modify how the assets are distributed among beneficiaries. Or you could be adding newly acquired assets to the trust. Changes in personal circumstances, such as marital status, financial status, or health conditions, can also necessitate amendments. To amend a living trust, follow these steps. First, review your original living trust document to understand its provisions and identify the sections that need changes. Next, decide on the type of amendment. There are two primary methods: a trust amendment for minor changes or a restatement of the entire trust for major changes or multiple amendments. Then, draft the amendment. Clearly title the document as an amendment to the living trust, specify the date of the original trust and the date of the amendment, detail the specific changes being made, and include a clause reaffirming the unchanged portions of the trust. Sign and notarize the amendment. Both the grantor and the trustee, if different from the grantor, should sign the document in the presence of a notary public. Attach the amendment to the original trust document to ensure all parts of the trust are easily accessible and legally recognized. Finally, notify all relevant parties, including trustees, beneficiaries, and financial institutions, of the changes to the trust. When amending a living trust, it's important to maintain consistency in the document to avoid any confusion and potential legal disputes. Consider how the amendment might affect your estate taxes and consult with a tax advisor if necessary. If you amend your living trust, you may also need to update related estate planning documents such as wills, powers of attorney, and beneficiary designations. When changing successor trustees, choose someone you trust to manage your assets responsibly. In summary, amending a living trust involves reviewing the document, deciding on the type of amendment, drafting the changes, signing and notarizing, attaching the amendment to the original trust, and notifying relevant parties. While it's possible to amend a living trust on your own, consulting with an experienced attorney is highly recommended to ensure that the amendments are legally valid and correctly executed. An attorney can provide guidance tailored to your specific situation and help avoid common pitfalls.
Life insurance is a powerful tool in estate planning. Life insurance is a contract between you and an insurance company. In exchange for regular premium payments, the insurance company pays a death benefit to your designated beneficiaries when you pass away. There are several types of life insurance, including term life, whole life, and universal life insurance. Life insurance can be a critical component of your estate plan, offering several key benefits. One of the primary benefits is providing liquidity. When you pass away, your estate may need immediate funds to cover various expenses, such as funeral costs, outstanding debts, and administration fees. Life insurance provides a source of immediate cash, which can help your family cover these expenses without having to sell assets or borrow money. Another significant use of life insurance is paying estate taxes. Depending on the size of your estate and the applicable laws, your estate may be subject to federal and state taxes. These taxes can be substantial and may need to be paid within a relatively short period after your death. Life insurance proceeds can be used to cover these tax liabilities, ensuring that your heirs receive their inheritance without having to liquidate assets to pay the taxes. Let's look at some specific ways life insurance can be used in estate planning. First, funding buy-sell agreements. If you own a business, a buy-sell agreement is a crucial part of your succession plan. This agreement outlines how a partner's share of the business will be handled if they pass away. Life insurance can fund these agreements by providing the necessary cash to buy out the deceased partner's share ensuring a smooth transition and continuity of the business. Second, equalizing inheritances. If you have multiple heirs and not all of them are involved in the family business or other substantial assets, life insurance can provide a way to equalize inheritances. You can leave the business to the heirs who are involved and use life insurance proceeds to provide an equivalent value to the other heirs, ensuring that everyone is treated fairly. Third, covering final expenses. Life insurance can help cover the costs of your funeral, outstanding debts, and other final expenses. This relieves your family of the financial burden and allows them to focus on grieving and healing. Fourth, providing for minor children. Life insurance can ensure that your young dependents are financially secure. The proceeds can be used to cover their living expenses, education costs, and other needs until they reach adulthood. There are several benefits to using life insurance in estate planning. Life insurance proceeds are generally tax-free for the beneficiaries, providing a tax-efficient way to transfer wealth. Additionally, life insurance offers flexibility and control over the distribution of assets, allowing you to tailor your plan to meet your specific goals. Knowing that your loved ones will be taken care of can provide peace of mind. Setting up life insurance for estate planning involves careful consideration and planning. It's important to work with a qualified estate planning attorney and financial advisor to determine the right type and amount of coverage for your needs. They can help you choose the appropriate policy, designate beneficiaries correctly, and integrate life insurance into your overall estate plan. In summary, life insurance is a versatile and valuable tool in estate planning. It provides liquidity to cover immediate expenses, helps pay estate taxes, funds buy-sell agreements, equalizes inheritances, covers final expenses, and provides for minor children. By incorporating life insurance into your estate plan, you can ensure the financial security of your loved ones and the smooth transition of your assets. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified estate planning attorney or financial advisor. See you in the next video.
Understanding special needs trusts. In this video, we will explain what a special needs trust is, its benefits, types, key considerations, and common mistakes to avoid. A special needs trust, or S&T, is a legal arrangement designed to manage assets for the benefit of a person with disabilities without disqualifying them from government benefits, such as Medicaid or Supplemental Security Income, known as SSI. The primary objective is to enhance the quality of life for the individual by providing financial support for needs not covered by government programs. Special needs trusts offer numerous benefits. They ensure that the beneficiary continues to qualify for essential government benefits, provide a steady source of funds for additional care, safeguard the beneficiary's assets from creditors, allow professional management of funds, and offer peace of mind to families. There are three main types of special needs trusts. First-party special needs trusts are funded with the beneficiary's own assets, such as an inheritance or a personal injury settlement. Third-party special needs trusts are funded by someone other than the beneficiary, typically parents or grandparents. Pooled special needs trusts are managed by nonprofit organizations and pool resources from multiple beneficiaries for investment purposes, while maintaining individual accounts for each beneficiary. When creating a special needs trust, there are several key considerations. Selecting the right trustee is crucial. They must be knowledgeable about public benefit programs and capable of managing the trust assets effectively. Funding the trust properly is also essential, with common sources including gifts, inheritances, life insurance policies, and personal injury settlements. The trust document must be carefully drafted to comply with legal requirements and protect the beneficiary's eligibility for government benefits. Regularly reviewing and updating the trust ensures it continues to meet the beneficiary's needs and complies with current laws. Avoiding common mistakes is important in maintaining the effectiveness of a special needs trust. Ensure the trust is adequately funded to cover long-term needs. Choose a trustee with the necessary expertise and commitment. Properly structure the trust to preserve government benefit eligibility and regularly update the trust to align with the beneficiary's evolving needs and changes in the law. Setting up a special needs trust is a compassionate and prudent step in securing the future for someone you care about. It provides financial security and enhances the quality of life for individuals with disabilities. In this video, we'll explore how to choose the right executor for your estate, covering key considerations and steps to ensure your wishes are carried out. Choosing the right executor is a crucial part of estate planning. Your executor will manage your affairs, settle debts, and distribute your assets according to your will. Making an informed choice can provide peace of mind for you and your loved ones. An executor has several key responsibilities. They collect and manage assets, pay debts and taxes, and distribute assets to beneficiaries. They must act prudently, be impartial, and maintain detailed records. When choosing an executor, look for trustworthiness and integrity. Your executor should be someone you trust implicitly and who has a reputation for honesty. Financial acumen is also essential, especially if your estate includes complex assets. Organizational skills are crucial, as the executor must handle numerous documents and deadlines. They should also be able to handle stress and make sound decisions under pressure. Availability is another key factor, as the role can be time-consuming. Common choices for executors include family members, friends, and professionals. Family members and friends may have a personal interest in honoring your wishes, but it's important to consider their potential emotional strain and conflicts of interest. Professionals, such as lawyers or trust companies, offer expertise and impartiality but come with costs. Consider the size and complexity of your estate when choosing an executor. A large or complicated estate might benefit from a professional executor. Also, think about family dynamics and whether the person you choose can navigate potential conflicts. Geographical proximity can be beneficial, especially if your estate includes real property. Legal requirements vary by state, but generally, an executor must be of legal age, of sound mind, and free of felony convictions. Some states require executors to post a bond to protect the estate from potential mismanagement. You may also appoint co-executors to share responsibilities, but this can lead to conflicts if they disagree. Alternatives to traditional executors include corporate trustees, who provide professional management, and successor executors, who step in if your first choice is unable to serve. To formalize your choice, include your executor in your will, clearly stating their name and any specific instructions. Communicate your decision with your chosen executor and any successors, and review your will periodically to ensure it reflects any changes in circumstances. Avoid common mistakes, such as choosing an executor out of obligation, overlooking professional help, and ignoring potential conflicts of interest. Make a choice based on suitability for the role. Choosing the right executor requires careful consideration and foresight. To ensure your choice is legally sound and well-informed, consult with an experienced attorney. They can guide you through the process and help you select the best candidate for your needs. Thank you for watching. For more information on estate planning, be sure to subscribe to our channel and visit our website. In this video, we will explore the benefits and process of buying property through a trust. A trust is a legal arrangement where one party, known as the trustee, holds property for the benefit of another party, known as the beneficiary. Trusts can be used for various purposes, including estate planning, asset protection, and privacy. One of the main benefits of buying property through a trust is asset protection. Properties held in a trust can be shielded from creditors' claims and lawsuits. Additionally, trusts offer privacy by keeping ownership details out of public records. When it comes to estate planning, trusts allow for the efficient transfer of assets upon the owner's death, avoiding the lengthy and costly probate process. Trusts also provide control over how and when assets are distributed to beneficiaries. Properly structured trusts can offer significant tax benefits, reducing estate taxes and providing other tax advantages. Several types of trusts can be used for buying property. A revocable trust allows the grantor to retain control and make changes to the trust. This type of trust is ideal for estate planning and can simplify the transfer of property after death. An irrevocable trust, once established, cannot be altered or revoked. This type of trust provides stronger asset protection and potential tax benefits. Charitable trusts allow property owners to support charitable causes while receiving tax benefits. Special needs trusts are designed to provide for beneficiaries with special needs without affecting their eligibility for government benefits. Now, let's go through the steps to buy property through a trust. First, establish the trust with the help of an experienced attorney. This involves drafting the trust document and naming the trustee and beneficiaries. Next, find a suitable property that aligns with your investment goals and the terms of the trust. If financing is needed, work with lenders who are familiar with lending to trusts. Ensure the property is titled in the name of the trust, not the individual, to maintain the legal protections and benefits of the trust structure. Once the property is purchased, the trustee will manage it according to the trust terms, ensuring that all obligations, such as taxes and maintenance, are met. Trustee duties include managing trust assets, maintaining the property, keeping up with property taxes and insurance, and acting in the best interests of the beneficiaries. Trustees must also keep detailed records and provide regular reports to the beneficiaries. Beneficiaries have the right to access trust documents, receive regular updates, and receive distributions as specified in the trust document. They must comply with the terms and conditions outlined in the trust and stay informed about the trust's activities. Key considerations for buying property through a trust include understanding the legal and tax implications. Trust laws can vary by state, so it's important to ensure compliance with local regulations. Engage an experienced attorney to navigate the complexities of setting up and managing a trust. Practical steps for trust management include regular property inspections, creating a budget for property expenses, and developing a prudent investment strategy for any income generated by the property. In summary, buying property through a trust offers significant benefits, including asset protection, privacy, estate planning advantages, and tax benefits. However, it requires careful planning and management. Consider seeking professional advice to ensure your real estate investments are secure, efficiently managed, and aligned with your long-term goals. A charitable remainder trust is an irrevocable trust that provides the donor with income for life and a current tax benefit for planning to donate assets upon their death. The donor gives away assets to an irrevocable trust, and during their lifetime they receive income from the trust. When they die, the remainder in the trust goes to the charities of their choice. When an asset is transferred into an irrevocable trust, it is removed from their estate. As a result, the assets in the trust cannot be recovered by creditors, and no estate taxes will be due upon their death. Additionally, because the assets are no longer owned by the donor, other advanced estate planning methods may be used in conjunction with a charitable remainder trust. Finally, for their generosity, the donor will receive an immediate income tax deduction when the charitable remainder trust is funded. The tax deduction amount is based on the current value of the assets that will go to charity. Irrevocable trusts are complex and must be precise. Be sure to talk with a professional. All forms of trusts are important asset planning and protection tools that have their specific place. For more information on wills or trusts, contact a professional.
Think a will is enough? Here's why a living trust might be the smarter move. First, living trusts avoid probate. Unlike a will, a living trust keeps your assets out of court. That means faster transfer to your loved ones and no costly probate fees. Second, living trusts provide privacy. Wills become public record, but trusts stay private. Your family matters, stay your family's business. Third, living trusts have flexibility. It's called living because you can change it any time while you're alive. Update it as life changes. And fourth, living trusts provide continuity. If you become incapacitated, your trustee can step in immediately, with no court delays. Bottom line, a living trust saves time, money, and stress for your family. Want more estate planning information? Hit subscribe.
Some people believe that wills are only necessary for the very wealthy or those with complicated assets. However, there are many good reasons to have a will. You can be clear about who gets your assets. You have more control and can decide who gets what and how much. Your heirs will be able to access your assets more quickly and easily. Additionally, with proper planning, you can plan to save your estate money on taxes. You can also give gifts and charitable donations, which can give tax benefits. However, even if you have a will, upon your passing, your assets will be routed through the probate process. Probate is the legal process that occurs to your estate after you pass away. This is a court-monitored process where the debts of the estate are paid and distribution is made to the heirs. The probate process will flow smoother with a will. Probate costs money and can take significant time. With proper estate planning, probate may be able to be avoided. Trusts can accomplish the same goals as a will, but oftentimes in much better fashion. When a trust is properly set up, it can avoid probate entirely. Any assets that belong to the trust will not be routed through probate. Often, a type of will, a pour-over will, is used in conjunction with creating a trust to ensure all assets are covered, even if they are not properly moved to a trust. To ensure your will or trust is done properly, contact Heritage Law Office today. Can you sell a house that is in trust? If you own property and are thinking about establishing a trust to safeguard your assets, many people ask, can you sell a house that is in a trust? The answer is generally yes, although the process can be intricate, requiring a thorough understanding of the various steps involved. In this guide, we'll walk you through the basics of selling a house that is in trust, including what a trust is, how it affects the sale of your property, and what steps you need to take to sell your home successfully. We'll also offer some tips on how to ensure your sale goes smoothly and efficiently, so you can get the best possible outcome for your situation. What is a trust? First, let's define what a trust is. A trust is a legal arrangement that allows you to transfer ownership of your assets to a trustee, who will manage those assets on behalf of the beneficiaries you name in the trust. The trustee has a legal duty to manage the assets in the trust in accordance with your wishes, as outlined in the trust document. There are different types of trusts, but the most common is the revocable living trust. With this type of trust, you can transfer ownership of your assets to the trust during your lifetime and retain control over them as the trustee. You can also name yourself as the beneficiary, so you can continue to use and enjoy your assets as you did before they were placed in the trust. The trust becomes irrevocable after your death, at which point the assets are managed by the successor trustee you named in the trust document. An important question to ask is, how does a trust affect the sale of a house? If you've transferred ownership of your house to a trust, the trust now owns the property, not you personally. This means that you can't sell the house yourself. The trustee must handle the sale on behalf of the trust. However, as the grantor, creator of the trust, you can give the trustee the power to sell the property by including specific provisions in the trust document. For example, you can include language that allows the trustee to sell the property at any time or only under certain conditions, such as when the beneficiaries agree to the sale. It's important to note that the trustee has a legal duty to act in the best interests of the beneficiaries when managing the assets in the trust. This includes the sale of the house. The trustee must make decisions that are in the best interests of the beneficiaries, such as selling the property for the highest possible price or using the proceeds of the sale to benefit the beneficiaries in another way. Here are the steps to selling a house that is in trust. Now that you understand the basics of how a trust affects the sale of a house, let's walk through the steps involved in selling a house that is in trust. Step 1. Determine the trustee's powers. The first step is to review the trust document to determine the trustee's powers regarding the sale of the property. If the trust document grants the trustee the power to sell the property, the trustee can begin the process of listing the property for sale. Step 2. Choose a real estate agent. The trustee should choose a reputable real estate agent who has experience selling properties that are in trust. The agent should have a deep understanding of the legal and financial aspects of selling a trust property, as well as the ability to work collaboratively with the trustee and beneficiaries. Step 3. Prepare the property for sale. Before listing the property, the trustee should prepare it for sale. This may involve making necessary repairs and improvements, staging the property, and setting a fair market price based on comparable properties in the area. Step 4. List the property for sale. Once the property is prepared, the trustee can list it for sale with the chosen real estate agent. The listing should include all necessary information about the property, including any disclosures required by law. Step 5. Accept an offer and negotiate. When a potential buyer makes an offer on the property, the trustee should review it and consult with the beneficiaries before accepting or rejecting it. If the offer is accepted, the trustee should negotiate the terms of the sale, including the price, closing date, and any contingencies. Step 6. Transfer ownership of the property. Once the terms of the sale have been agreed upon, the trustee should work with the real estate agent and the buyer's attorney to transfer ownership of the property. This may involve completing necessary paperwork and providing documentation related to the trust and the sale of the property. Step 7. Distribute proceeds to beneficiaries. After the sale is complete and any outstanding debts and expenses related to the property have been paid, the trustee should distribute the proceeds from the sale to the beneficiaries in accordance with the terms of the trust. Selling a house that is in trust can be a complex process, but by following these steps and working with experienced professionals, it can be a smooth and successful transaction. Thank you for tuning in, and if you have any further questions or need legal advice, feel free to reach out to us at Heritage Law Office. If you found this video helpful, don't forget to like, share, and subscribe for more informative content.
So you want to put your home into a trust? It's easier than you think. Here's how to do it in 3 steps. Step 1. Gather all your property documents and trust paperwork. You need to know what you're working with before you start. Step 2. Choose the right type of trust for your needs. Revocable, irrevocable. Pick what suits you best. Final step. Transfer the title of your home into the trust. Just like that, your home is protected and secure. Want more? Follow for more estate planning videos.
Today, we're diving into a critical issue that affects many homeowners: HOA overreach. Homeowners associations are designed to enhance and maintain the quality of our communities. However, when an HOA oversteps its bounds or fails to meet its obligations, it can create serious problems for homeowners. In this video, we'll guide you on recognizing and effectively combating HOA overreach. Recognizing HOA overreach can manifest in various ways, including: Number 1. Excessive fees. This includes unjustified increases in costs or unexpected assessments. Number 2. Unfair rule enforcement. This means selective or inconsistent application of rules. Number 3. Poor financial management. This refers to mismanagement or lack of transparency in handling community funds. Identifying these issues early is crucial to protecting your rights as a homeowner. To build a strong case, meticulous documentation is key. Keep communication logs. Record all emails, letters, and phone calls with HOA representatives. Keep meeting minutes. Keep copies of official meeting notes and any personal notes taken during meetings. Document incidents. Record specific incidents of overreach, including dates, times, and descriptions. This documentation will be invaluable if you need to escalate your complaint. Start by addressing the issue within the HOA. Attend meetings. Be an active participant in HOA meetings. This is your platform to voice concerns and suggest changes. Communicate clearly. Present your case calmly and factually to the board. Sometimes, open dialogue can lead to resolution without further conflict. If internal efforts fail, it might be time to seek external help. Mediation. A neutral mediator can help facilitate a fair resolution without going to court. Legal counsel. If mediation doesn't work, consulting a lawyer who's experienced in HOA disputes may be necessary. Legal action should be a last resort, but can be effective if your rights are being violated. Consider the story of Sarah, a homeowner who faced unreasonable fines and mismanagement of community funds by her HOA. By diligently documenting the issues and seeking legal counsel, her persistence led to a fair resolution, improved community governance, and protection of her rights. Don't let an overreaching HOA disrupt your peace of mind. Feel free to take action if you're facing issues with your HOA. Protect your rights and ensure your community is managed fairly. For more information or assistance, contact us today. Remember to like, share, and subscribe for more valuable insights on protecting your rights as a homeowner. See you in the next video.
Imagine this. You've spent decades building your dream business, only to have it crumble because of a simple oversight in your estate planning. Sounds dramatic, right? But it happens more often than you think. Picture this. Your family is left fighting over your assets. Or worse, your business gets tangled in probate for years. Now, here's the kicker. Many people believe that just having a will is enough. Spoiler alert, it's not. Trust can save your loved ones from a legal nightmare, and they can even protect your business from unexpected taxes. Don't leave your legacy to chance. Plan ahead, avoid the pitfalls, and ensure your hard work doesn't go to waste. Your family and your business will thank you.
Titles and deeds play a pivotal role in legally recognizing and transferring property ownership. Join us as we break it down. What is a title? A title represents legal ownership of a property. It's the evidence that proves you have the right to possess, use, and control a piece of real estate. But what happens when you want to transfer that ownership? The importance of the deed. A deed is the legal document that conveys ownership from one party to another. Think of it as the passport for property, transferring the title and its associated rights.